All right, well, good morning, everyone. Welcome to OCRC 101. My name is Jordan Harder. I'm from the Department of Administrative Services, and I'll be moderating this session. I have just a couple of announcements before we begin. First, we invite you to submit questions or comments in the meeting chat. The presenters will do their best to address these at the end of the session. Second, this session is being recorded and may be posted online or made available for on-demand access. This session is presented by Darlene Sweeney Newbern, Director of Regional Operations at the Ohio Civil Rights Commission, OCRC. Another reminder, if you are attending this class for CLE credit, please be advised first that to receive CLE credit, you must complete the course survey and the OCRC 101 review by Friday, August 26th. The course review will require the following information to complete and submit. The program name is OCRC 101, and the activity code is 497480. I will post this in the chat momentarily. Please contact Chelsea Wansky at DAS with any issues with the CLE credit, and I will post her email information. All right, and now please welcome Darlene.
Hello, everyone out there in as modern times, Zoom land or Teams land or whatever land. And thank you so much for inviting me. Love to talk about the Ohio Civil Rights Commission. So I'm going to give you an overview of the Ohio Civil Rights Commission and the laws that we cover. I'm going to tell you from the start that the Ohio Civil Rights Commission really is just 5 commissioners. They have a term of 5 years. They're appointed by the governor. The executive director of the Ohio Civil Rights Commission is Angela Phelps White. She came aboard in March of 2020. An interesting story about that is that when she came aboard, it was the day that we all went out basically because of COVID. So her first day there at the commission is like, oh, okay, now we're in a crisis and I have to do crisis management already. So that is the executive director of the Ohio Civil Rights Commission. So I'm going to give you the ABCs of the Ohio Civil Rights Commission. And what I have in front of you is what I'm going to attempt to do in this particular session. This is interactive. I welcome any and all questions. I welcome your interaction. Please feel free to participate. I think this would be a lot more interesting to you if you participate along with me. What I'm attempting to do is demystify the Ohio Civil Rights Commission for you. I want you to understand the laws that we cover. The Ohio Civil Rights Commission enforces Ohio Revised Code 4112. And with that comes great power and responsibility for the Ohio Civil Rights Commission. I'm going to break this down for you. And again, any questions, feel free. I'm also going to try to educate employees, supervisors, and managers on rights and responsibility. Supervisors and managers learn what to and not to do. So I have a special session of this PowerPoint just for you. So hopefully you will enjoy this and you will understand and get something that you can take back with you. Here we go. And I'm saying, oh, great. Here we go with this stuff right here. But it's interesting. The Ohio Civil Rights Commission, we don't just generally cover your rights. We don't just say if there's generally some type of employment problem, hey, we're going to cover this. We are not a super personnel agency, but we're actually a law enforcement agency. There are several individuals out there, they don't realize that we are law enforcement. And we enforce Ohio Revised Code 4112. And under Ohio Revised Code 4112, it is a mandate that our responsibility that we investigate in the areas of employment. And under employment, there are many subtitles that I could talk about here. Just know everything that has to do with your employment from the time you make application to the time you are no longer employed, even after you are employed, there may be an issue. The Ohio Civil Rights Commission will cover this. Places of public accommodation. I'm going to talk about that a little more. I am going to focus this presentation on employment here. But any place that the public can go, you have your hotels and restaurants, you have dentists and doctors' office, you have places such as these gaming places, just any place that basically the public can go. A lot of people didn't realize that the Ohio Civil Rights Commission actually has jurisdiction over there. You hear about individuals talk about they were followed around in the stores, in the malls. I can tell you that the Civil Rights Commission, we do receive complaints about, hey, I was discriminated against because I was followed around in the stores and the mall. But there are people out there that just didn't realize that. So now that you have that knowledge, you are empowered here and you can share. I would love for you to share this information with the public, with people in your family, with just everyone at the types of things we do. I don't know if people realize that the Ohio Civil Rights Commission, we cover housing discrimination. So we're not just an employment agency. And this is all aspect of your housing. We actually cover you from the cradle to the grave when it comes to housing, because there's just some unlawful discriminatory acts that's just not acceptable in housing. And there's so many people we learn that just do not realize that. They don't even realize that the Ohio Civil Rights Commission even cover burial lots. We find that there's discrimination going there as well. I'm assuming that everyone can hear me okay. Yes? Anyone? Yes, I have some thumbs up. Sometimes, because I'm so used to being in front of people and walking and talking and interacting, when you're doing it remotely, sometimes you're just not sure if you're being heard here. So thank you for that thumbs up. We also protect you when it comes to credit. Look at, oh, thank you, Beth. Because Beth gave me some feedback already, Beth, I can virtually send you a whole box of Lysol or Microban. Because, these are the things we need these days. We used to give different type of gifts, but now we want the stuff that's going to fight COVID and anything else that's out there. So thank you. So under credit, if you actually apply for credit, take a look closely at what that credit application says. And it will tell you that if you have any problems, if you are denied credit, call the Ohio Civil Rights Commission. And then we also do higher education, but only in the area of disability. Other than that, the commission has no jurisdiction. So remember, these are what I just presented to you were the areas that we cover. Why am I telling you that? Because of the calls that we get. We'll get a call that says something like this: you have to do something. They're taking away my children. And that's violation of my civil rights. And we'll say, well, we do not have jurisdiction over, of course, taking away your children. This is civil rights, isn't it? Well, my civil rights are being violated. However, we are limited in what it is that we can do. While our powers are great, while our authority is great, we don't cover this. And these are our protected classes. So the Ohio Civil Rights Commission covers under race, color, religion, sex, national origin, ancestry, disability, age. If you're at least 40 years of age, except for credit, you can get by with just being 18 years of age. We also do marital status. We also do military status. Military status was the latest that was added a few years back. Our military brothers and sisters will go to war, they will fight or they put their life on the line, and they will come back and find out that they can't get jobs, that they can't get housing. They may have left a family behind and their family got kicked out. Um, um, I see before I continue on, and I will do this, there's a question that says, what are some examples of violations with disability in higher education? Generally, we find that someone with a particular learning type disability may need an accommodation for test taking, such as a longer time to more time to take a test. They may need to be isolated in a room um, because the noise would be distracting to them. Most of the cases we see has to do with given more time to do tests and maybe a different way of learning. They may need even someone there with them that would assist them in understanding the material. Okay, you're welcome here.
Hey, Darlene, this is Jordan, your moderator. I can read out the questions out loud if that works for you, or I can save them till the end. It seems like you want to take them as we go. That works for me.
Yeah, that works for me, taking them as they go, because I
Okay.
want to hit it right there on the spot. And then
Got
if
it.
there's some in the end, and yes, Jordan, that's fine. If
Okay, I will try
would
to
do that.
voice them and I'll bring them to
Yeah,
your attention.
yeah, because I don't want to miss a question here. Um, and so we also have sex discrimination, and a subset of sex discrimination is just several different types of categories that goes on. Condition of pregnancy will fall under sex discrimination. It is simply unlawful to discriminate against an individual because she is pregnant. We're going to talk later about sex stereotyping. We actually have these cases. All the stuff that I'm telling you, the commission, we routinely have these cases. We have probably right now more than 2,000 cases in our system. And that's including, that's just employment. We also have housing cases as well. We probably do at least three, even 400 housing cases per year here. Um, so is now we also have sexual orientation. That was added recently as well, where before, if you filed a charge said that I believe I was discriminated against based on my sexual orientation, the commission will also investigate and take a look at that. That is basically a new area. I think plenty of employers are dealing with this particular area right here. The commission is, we're still developing in this area, but we pretty much believe we have this under control. So these are our protected classes. We may get a call talking about my boss can't stand me, my boss doesn't like me, and then we would go through the protected classes to say, is it based on race, color, religion, sex, national origin, ancestry, disability? And it's like, no, 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 it's none of those. Well, we would say the commission doesn't have jurisdiction. My boss just doesn't like me. You know what? It's just jealousy. That's all it is. We're saying, yeah, if that's what it is, that's not jurisdictional for the commission. Well, it's because of my political affiliation. Good. Then guess what? We don't have jurisdiction, because if you notice about our protected classes, political affiliation is not one of the protected classes. These are our protected classes. I will be referencing this. And retaliation is another one. Why did I start retaliation? Because in order for it to be retaliation under our statute, you must have alleged discrimination on one of our protected bases, or you must have participated in what we call a prior protected opposition. And what that means is maybe you served as a witness in a case that was based on one of the protected classes. Maybe you went to a manager or someone and you said, hey, I feel like I've been discriminated against because of one of the protected classes. As long as you did some type of participation based on one of our protected classes or bases, because I'm using that interchangeably, then indeed you fit in retaliation class. We have retaliation where or allegations where it was whistleblowing in a factory setting. I went and I reported that this was a safety violation, and next thing I know, I'm fired. And we would say that sounds terrible, but it's not one of our protected classes. Therefore, is not really anything that we can do about this. Jordan, you have a question.
We have a question in the chat.
Mhm.
Does there have to be a documented, established pattern for a violation?
Um, Not necessarily a document established pattern. It depends on allegation, what the allegation is. For example, I can say, hey, I believe I was discriminated against. I was given a demotion because of my disability. Well, there's no show of a pattern that is needed. What is needed is to decide how, not to decide, but to inquire who made that decision, why was this person demoted, and to determine if, at least in part, it doesn't have to be the sole reason, but if at least in part you consider this person disability, then you could possibly, chances are it's more than a possibility, you're going to be in violation. The commission standard is a more likely than not standard, probable cause or no probable cause. That too will be discussed throughout this presentation. It
And
looks
then
like
we
there's
have
another.
And then a follow-up question. What if an employee files a complaint alleging political discrimination, which is not jurisdictional, but later claims he or she was retaliated against because of filing the non-jurisdictional complaint? Ooh, good question.
Now, this can get real tricky here. Remember what I said, when you file a complaint, it has to be on our jurisdictional basis. So you actually file the complaint and we say this is non-jurisdiction. But guess what? Even if that underlying claim is a non-jurisdiction, but you were discriminated against because you filed this with the Ohio Civil Rights Commission, then yes, the commission would take a look. For example, you said, for political reasons, I was suspended. And we said, sorry, we took the complaint in, we give you a decision of no jurisdiction. The respondent, that's who the charge is filed against, then receive this, what we call a no jurisdictional finding. They turn around and says, oh, you went to the Ohio Civil Rights Commission, you're fired. Yes, now you have a jurisdictional complaint. You have a jurisdictional complaint here that we will at least take a look at. Was that helpful?
Let you know if there's any follow-ups in chat, but I think that covers it.
Yeah, we've had that scenario. So how do we file these charges? So Darlene, you said, hey, the Ohio Civil Rights Commission is a law enforcement agency. Actually, I will let you know that we are the leading law enforcement agency in the state of Ohio that enforces Ohio Revised Code 4112. I will let you know that we're not the only one, but we are the leading one. We are the state agency that enforces your right in the particular areas of employment, housing, credit, of public accommodation, higher education. So but you just can't file 15 years ago something happened to you and you said, you know what? I meant to file that 15 years ago. I'm going to file now. I think I can still prevail on this. So when must a charge be filed? This is important right here. For employment, a charge must be filed within 2 years from the date of harm. If you said, I was demoted, there's a date certain when you were demoted, then you have 2 years to file that charge. If you were terminated, if you said you were harassed, the date, unless it's ongoing, which harassment is generally ongoing, um, again, 2 years. It used to be 6 months, but we'll discuss again why it's no longer 6 months. For public accommodation and higher education both, a charge must be filed within 6 months from that date of harm. So if you were followed around in the mall, you have 6 months to file that charge. I notice we get an influx of charges generally around Christmas time when the stores start catching people stealing, and they would then file charges saying, hey, they discriminate against me. Generally, they're trying to avoid a prosecution here, criminal charges being pressed, and say, hey, let's settle this case. You don't file criminal charges, I'm withdrawing the charge. But there have been plenty of public accommodations where people kicked out of the clubs or the nightclubs where they have stuff like these dress codes saying, yeah, if you come in with particular colors, or if you have a hoodie, or if you wear a jersey. And we've had charges where people disproportionately, when you have stuff like that, that's we have the race cases. I've seen it mostly race cases when it comes to the public accommodation, but everyone in every category is covered, and the commission will indeed investigate. Credit charges must be filed within 180 days. Language is important. That is the only time we're specifying 180 days. Do not get 6 months confused with 180 days, because all my attorneys that's attending right now, they would tell you, oh no, it's a difference. So I'm telling you, it's a difference here when you're counting for jurisdiction. Housing charges must be filed within 1 year. When you file an employment charge with the Ohio Civil Rights Commission, sometimes, or most of the times, it is duly filed with the EEOC or the Equal Employment Opportunity Commission. The EEOC is the federal agency that enforce the laws against discrimination in employment. And of course, OCRC is the state agency. We are what you call substantially equivalent. Generally, when you file a charge with Ohio Civil Rights Commission, it's duly filed with the EEOC. There is a criteria for that, generally, depending on your basis. But for the most part, if you have 15 or more employees, it's going to be duly filed with EEOC. And a housing charge is generally duly filed with HUD. So this clock, it usually begins to tick on the date of knowledge when you know this information. There has been, and this is rare when it's up on discovery, I just found this information out. Individuals have successfully went that route, but the commission is actually going to determine, is this information that was available to you and you should have known. The best way to get a charge filed is to be aware of the statutes here. There's something called a continuing violation theory. This generally has to do with policies. And if there is a policy that's at question here, you're going to find that there's a continuing violation. Who can file? Everybody. basically everybody can file a charge here. We even have individuals, you do not have to be an adult to file a charge. Sometimes young adults or young children have to file, or their parents can file, because anyone can file on behalf of anyone. You can file if you are a harmed party. You believe you have suffered some type of harm. You can file. You can be a third party. You can have a friend or family member or child, or can even be a stranger. Anyone can file on behalf of anyone. And you would be Jane Doe filing on behalf of John Doe. And then you will go into the narrative explaining what happened to John Doe. Keep that in mind. We get that question a lot. Individuals want to file and say, well, I'm afraid. But you can actually file on behalf of that person. You can be an advocacy groups. There's all types of advocacy groups out there, particularly your disability advocacy groups. In housing, there are several advocacy groups that's live and present and active. Or the Ohio Civil Rights Commission, we actually have the option of self-initiating in all areas except housing and public accommodation. We don't have authority to self-initiate there. But sometimes when we hear about a case and we see that there's this other type of discrimination that's going on, and it's not this particular discrimination at all, then the commission can self-initiate under those circumstances. And we have done that in the past. The parties, against whom can a charge be filed? The respondent. The respondent, again, is the entity or the individual that's the target of the charge of party, the person filing the charge. So that entity, that person, that organization that the charge is filed against, that is called the respondent. But again, we need jurisdiction here in Ohio. We just can't take and say, oops, they filed against you, so it's okay. When the commission receives the charge, the first thing we're going to do is check this jurisdiction. And so for employment, for the state of Ohio, we need that employer to have 4 or more persons. You can file against any labor organization. It's not widely understood that just because there's a union, it's not going to supersede the Ohio Civil Rights Commission authority here. In fact, we can investigate the union and its practices. And we have. Sometimes we've received charges where they're saying, no, the union and the employer, they were in this together. In fact, that happened in the GM cases. I don't know, by giving me thumbs up, if you heard of the General Motor cases a few years back, where they were hanging nooses in the workplace and making racial slurs, and they were on the bathroom walls, they wrote racial slurs and bathrooms for whites only. And boy, some of the stuff, I see that question. I'm gonna finish this real quick. So they also said that the labor organization was part of this, and the commission also investigated the labor organization right along with the employer and found both were, in fact, engaged in discriminatory treatment of their employees. We're over employment agencies. It is not okay for an employment agency to not send someone on assignment based on their race, color, religion, sex, national origin, ancestry, age, if you're at least 40 years of age, disability, military status, or in retaliation for complaining about any of these types of things. We have found that Indeed, that's happened. What we see in employment agencies, and again, I'm trying to empower you. If it doesn't affect you directly, perhaps it does someone that you love, care about, you know. The employment agency says, hey, it's not me. The individual place that I'm sending this person, they set forth a criteria and they said, we don't want any women here. Basically, we want a bunch of men. They're going to talk the way they talk. I mean, this happened for real. And therefore, a woman, we don't want a woman here. That's discriminatory, everyone. They don't get to do that. And we would say, really? And we would tell the charge party, and make sure you file a charge against this particular place so we can go ahead and investigate this as well. Because if we don't do this, they will point fingers back and forth. No, I didn't say it. Yes, you did. So they will go back and forth. Temporary agencies, anything that has to do with employment, if they're going to not hire you for which you qualify on something that's under our jurisdiction, we indeed will investigate. Go ahead, Jordan. There was a question about the
Yes,
migrant.
a question, can a migrant seasonal farm worker here on a visa file against an employer?
Sure can. The Civil Rights Commission, that would, we do not ask people if they are here on a visa. We do not ask about their status to be in the United States. None of that. That is not something we are concerned with. All we are concerned with, were you discriminated against in your employment? Now, this is where it gets interesting. Retaliation, housing, aid, and abet. Notice that I said for employment, when it comes to an actual employer, we're going to start off with at least 4 more employees. When you have retaliation, our statute changes a little bit. And instead of saying any organization, any this or that, it says any person. So what that means for everyone out here is that you can get a personal charge filed against you as an individual. And when you talk about aid and abet, what that means basically, if the person says, hey, it was that human resources director that fired me, and I believe she was put up, or he was put up to do it. So I'm filing against them too, because they aided my employer in the discriminatory treatment. That's what aid and abet is about. And that's also what retaliation, saying, hey, someone retaliated against me. Because I complained about a coworker, that coworker came for me, and my boss knew it. Or I complained about a boss, and that boss came for me. That could be retaliation. Go ahead, Jordan.
All right. Maybe along the lines of that aiding and abetting topic, can a temp agency comply with a client's request not to place a worker because of protected class membership?
Absolutely not. That's what I was saying earlier. You cannot deny an individual employment, even if an agency says, I don't want a person based on their sex or race or national origin or ancestry. Please do not send me anyone that's disabled, particularly if there's a mental disability. Oh no, don't send them here. That's if that temp agency comply with that request and the charge is filed, number one, they probably won't tell us outright that that's what they did, and that make us go a long route to find that information out. It is unlawful to do that. They don't get to make that call whatsoever. Okay. Credit. And basically it's any person who extend credit to these credit card companies. It could be banks. If it's for a mortgage, that's going to fall under higher education instead of credit. And for higher education, we're saying that it's the state university of colleges. It is all any kind of state assisted institution. If there's programs like there's specific welding programs or some kind of skill level program that's considered a higher education, all of that stuff is covered, but only again on the basis of disability. So what happens there when individuals file these charges, the commission, if we find that there's a violation, the commission will conciliate. The first thing we'll do is attempt to conciliate these cases. I'm going to come back to this slide because I'm going to talk about the investigation. Then I'm going to talk about the remedies, and we're going to go back to this slide for the remedies. We're going to go with investigation. So what do we do? As a law enforcement agency, we have access to all records, documents, files, emails, people, your computers. We have access to everything that we need in order to bring forth a recommendation to our commissioners as if to determine if the laws against for discrimination based on what we cover have this been violated here? Is there a violation here? But how can you file this? Well, you can file this charge online. Ohio Civil Rights Commission. Really, if you just Google Ohio Civil Rights Commission, it's going to come right up. We just relaunched our website. Yay! Looks very nice. So just give it a try with Ohio Civil Rights Commission. There is a section there which allows you to file this online. We were having you file in person. Right now, we're still remote in terms of actually having people come into the office to file charges. That will be changing in the future. You can do snail mail. Remember the old, we're going to put it in in the mail. Right now, we're in the world of we want everything instant. Or we can get a charge in if it's a transfer for EEOC. It could be a transfer from HUD. And once we receive a charge, the first thing we're going to do, once we get a signature and get an oath, or we ask that you notarize, you swear, you affirm. Once we take care of the preliminaries, we're going to serve that charge on the individual or the organization that that is alleged violated the revised code. But we're going to offer mediation on almost every case. We offer mediation. Why? Couple things. We have this wonderful mediation program and other charges that go to mediation. So I would encourage you if you have to do this, to take advantage of our mediation program. I think we have a success rate like over 80% of cases that go to mediation that are mediated. And then mediation creates a win-win situation. You're not going to get everything that you wanted, and you're not going to give up everything. So it creates a win-win situation. If not, we're going to go to investigation. The next part of the investigation is just our document gathering phase, which also includes attempt to settle. What is an example of a case where you would not offer mediation? An example of a case where we would not offer mediation is all cases we have to look out for the public interest. But if it's a major case, and we may have 80 or 90 what we call charging parties because it's systemic in nature, we would not want to offer mediation to one or two people. Because they can create this win-win situation, but there's a whole lot of people who did not file a charge, and it may be a discriminatory policy that's out there that's still in existence. So because we there. We have to do we have to investigate those cases just to make sure that that workplace is free of discrimination and they're following the laws governing discrimination. We also, for example, in housing cases, if indeed someone says, you know, I went to my insurance person, I tried to get a policy, and that insurance person says, because of where you live, we're not going to give you a replacement value policy. That is a bigger issue here. We don't want them to mediate and give that person the policy that they want because everyone that's in this particular category here has possibly been discriminated against. The commission will have to take a deeper delve into this to make sure that the public is protected. Was that helpful to you, Monique? Okay, so then we go to the document gathering phase here. Mediation failed, we go to document gathering stage. And during that is when we start gathering document. We would send out a request for information. We're going to ask all sorts of questions. It's during this investigative phase that we're going to interview individuals. We're going to analyze information. We're going to discuss it internally. And in the end, we're going to make a recommendation. And so the recommendations that are available to the commission is that the person says, commission, I'm going to withdraw my charge. They withdraw charges for a variety of reasons. I'm just going to go to court. I'm not going to pursue this with you all. I understand what happened here. Therefore, I no longer wish to pursue this. So there's a variety of reasons which someone would withdraw a charge. Or it will be administrative closure. OCRC would close this case. We may close this case because EEOC said, you know what? I want this case. I already have 3 cases against this particular organization. We want you to close that case and send it to us. Or it could be a duplicate charge filed. So there's a few reasons why we administratively close. We may bring forth a recommendation of probable cause. If it is a probable cause finding, that's when we must attempt to conciliate. If it's a no probable cause, if it's no probable cause, then we have the problem. It's not a problem, but then the person receiving, I should say like this, the person receiving the adverse finding can request what we call reconsideration of that finding. A no probable cause is generally a final order of the commission. If you request reconsideration, we then set that finding aside and then we start over and kind of take a second look here. If it is probable cause, we will go to the conciliation. That was the one slide that I had. I was trying to get this thing to go backwards for me, but for some reason it won't let me go backwards. It wants to go forward. So I can just tell you about the remedies and what was on that slide, and I believe that you all have access to this PowerPoint. Was there a question?
There wasn't in chat. I have a question. Are there any instances where you don't allow complainants to withdraw the complaint if they allege something egregious and you as an agency want to look into it, but they withdrew?
Yes, the request for withdrawal of charge is just that. It's a request. Before House Bill 352, which is coming up in a slide or two, we would stop an individual from withdrawing. Now we have to have a really, really good reason to prevent someone from withdrawing a charge. By the way, even if you withdraw a charge, remember the commission can self-initiate. So if it's a really big public issue, something that the commission really needs to go after, we do have the ability in some instances to self-initiate.
Thank you.
If there's a probable cause finding, for example, let's say someone was terminated and we felt that that was discriminatory, the types of remedies that you can get is reinstatement. You get all back pay. Maybe during this time, there was overtime that you could have received we kind of take a look at the average overtime that you could have gotten. Let's say that you had medical bills that would have been paid. So if you had insurance or if you had a particular plan, any out of pocket expenses is what I'm telling you all. You get your out of pocket expenses. Let's say that you lost any kind of time, whether it's comp time, personal leave, sick time. We go back, we can restore leave balances. Um, we can do, what we have to do is sort of rewind the clock here as a way to look at it. And we have to make it appear as though this didn't happen. Your record is clear. If your seniority date, if you lost seniority time, all of that is added as if this never occurred. So, whatever happened to you that you were receiving and then was terminated, we will back this up and we would say, hey, respondent, this is what the commission deems would make this right. If you say, look, that agency, that employer was so horrible, I don't want to go back there under any circumstances, and they owe me, we do have something called front pay. And front pay is when they pay you a year or two salary as if you did work there. We don't have a lot of front pay issues, but that is another option here. Sometimes people say, I feel like if I go back, I'm going to be retaliated against. If that's true, you do have a right to file the retaliation charge. And the commission, well, we're right back. We do warn employers, do not retaliate because an individual has exercised its right to file a charge of discrimination here. If conciliation fails, conciliation is not an option. We must attempt conciliation. That's if it fails. If respondent said, I think you're wrong, I request a reconsideration, even though the commission upheld the decision of probable cause, I don't care what you say, I'm going to fight you to the bitter end. It then is turned over to the Ohio Attorney General's office. That is our legal egos that litigate the Ohio Civil Rights Commission cases. And because the Ohio Attorney Generals will still be involved. Once we get past probable cause and conciliation fails, and it's even if we turn it over to the AAG's office, this is what you can do. You can either go to a hearing with our administrative law judges. In fact, you will hear from one of our administrative law judges later on, Bradley Dunn, and we also have Denise Johnson here. Denise probably is doing one of these presentations, if not today, one of these days. I wouldn't be surprised because she typically do these type of presentations as well. But they are administrative law judges, and then they will hear this case. Or you can request to go to trial, but that's not in employment. Housing has what we call the right of election. In housing, you could say, hey, you found probable cause, either take it to a hearing or take it to trial. Even after we made all these findings, even at the Attorney General's level, we still try to settle the case. Settlement, in most cases, always the best. Again, you create more of a win-win situation. We already discussed conciliation, or your case can just be dismissed at a hearing or trial. So let's get into these actual bases. So let's start with disability discrimination. That seems to perplex employers a lot. And a disability discrimination is any mental, physical impairment with substantially limit one or more major life function. You can have a record of it, or you can be regarded as this. what's interesting is that this definition is not hard to meet. We know that you had the ADA, and then somewhere in the 2000, I want to say like 2002 or so, you had the ADAA where they amended the act to make just about everything a disability here. What I want to tell you about disability for my employers out there, if an employee comes to you for an accommodation, please do not ignore that employee. You have an affirmative duty. This is not, if I feel like it, I'll do it. Maybe first I don't believe that this person, you have affirmative duty to engage in what is called the interactive process. That means you are going to have a dialogue with this individual going back and forth to see basically what is going on. You are not allowed to ask what the name of the specific disability. Some disabilities are obvious. You have to be careful about that because you can't impose a disability on anyone. If an individual comes to you and says, I need an accommodation, and that accommodation is, I need a special chair. Now, employers, and we actually have this, well, they even submit a doctor's note, and you can request a doctor's note substantiating that there's a disability and accommodation is needed. You do not have to buy the biggest and the best chair possible, but you do have to get a chair that's going to alleviate these symptoms that will help the individual to be able to perform the substantial functions of that job. Individuals ask for all types of accommodations. Sometimes you do have to maybe make a accommodation in a rule or policy just to accommodate a certain individual. But what you do not have to do ever, you do not have to lower your standards. You do not have to take away major job functions. An employee says, I give you an example here at the Civil Rights Commission. Part of what an employee must do is interview, talk, whatever. And the employee says, well, hey, I don't want to do the function of interviewing. Let someone else do my interviewing. I just get anxiety if I have to interview. No, that's a major function here. So in order to do this, you have to assess what is a major function of a particular position and what's not. You again, so you do not have to stop and say, okay, that duty right there, you no longer have to do. But you do have to make that accommodation. If you are confused as to how can I make this accommodation, I would like everyone to write this down, JAN. That's called Job Accommodation Network. And with Job Accommodation Network, there is not an accommodation that it cannot tell you about and how to make. Each of these categories I can spend more and more time on, but I want to make sure that I get through the whole presentation for you all. And so when a person requests accommodation, just look, there are no magic words. Employers out there, I want to say this to you. It is not a defense to say, well, we have a particular form. They came to us and they didn't use our form. And because they didn't use our form, we didn't make that accommodation. You'll lose. Once that accommodation, once they put you on notice, you are on notice. This slide is just telling you what I just told you. The slides was for your entertainment, not really mine. You must make the accommodation. Again, you can call Jan, Job Accommodation Network. Um, these are some of the things you can do. You can do some job restructuring as long as you're not taking away the central function of a job. There may be some equipment or devices that you can help a person with. A person maybe that's hearing impaired, you might can get a device where they can tag and on to their computer that will allow them to hear. For someone that's sight impaired, maybe you'll hire a particular reader that can help them. You might have to modify time. You do have a defense here, and that's is that due to business necessity you can't modify, or that is a reasonably high cost and you can't modify. Um, but basically, if it's a reasonable accommodation, make the accommodation. Real quick for the pre-employment inquiries, when it comes to disability, just basically don't tell people before you can hire them they have to take a physical exam. No, we do not do the GINA and the genetics, but there was actually and still is employees out there that want to swab your mouth and everything. They want to do a gene study on you to determine what kind of possibly illnesses or that you have or you possibly would get, and then deny you hire. Don't let people do that to you or anyone. That is unlawful. Let's talk about religion discrimination. Under religious discrimination, why I put this here is that religious discrimination be something something that's interesting, because to qualify as a religion, all you have to have is a sincerely held belief. It's just not the secular religion that you think it is. There are people out there, the pastafarians, who their God is pasta. And if you discriminate against them, they have a right to file a charge. I gave you some examples. There are people that has to do with hairstyle. We did have a case where it was hairstyle, and it was a certain hairstyle, and that was deeply in their religious belief here. You already know some religions cover the head covers. You have these people with tattoos, and you would be shocked as to what is religion. Someone comes to you and say, hey, based on my religion, I need a particular accommodation, or I can't do a particular duty. In one case that we had, where it was what I call the wand case, this individual had a wand, and the idea was when a pack or parcel come through the conveyor belt, whatever, you have to scan it. But that person noticed on that wand, it says something like 666. He says, I can't do this job. I cannot do this because this wand says 666. That's against my religious belief. That's the mark of the devil. And the employer says, yeah, well, bye, basically. And the employer lost big time for that. We've had it where there's still people today that do not believe in banks. And because they do not believe in banks, they said, I'm not going to put my check in a bank. And the employer says, you must have direct deposit in order to do this. This individual said, no, I don't believe it. The employer said, you're out. It's my religious belief. So religion is also covered. What I'm doing, everyone, is just giving you all highlights here. I'm not going into really deep details because that's really a 3 to 4 hour training if we got into the details here. Harassment, two types. When we talk about sexual harassment, that's quid pro quo. That's something for something. And the other one is hostile work environment. If you are a boss over someone, I'm telling you right now, I don't care if you were in these paramour relationships with saying no, they engaged, they were going together. If you are a boss, you have power, you have authority over that person. When this stuff breaks up, here comes these sexual harassment charges. As a rule of thumb, don't get your honey where you get your money, is all I can tell people to be on the safe side of this.
We had a question in chat, but I think you already kind of covered it. Reporting a safety concern and then being retaliated against
Yeah,
would
I
not
have.
be an
Right,
example. Yep.
right, right. And then for hostile work environment, that generally, even though it can be from your boss, um, hostile work environment can be also from coworkers. Anything of a sexual nature that is discussed, that is displayed, that is demonstrated in the workplace, you can get in trouble for that. I don't care if you have your own office, because that office is not yours. It belongs to the employer. So you are not allowed to hang pictures or disgusting words, and you're not to even have this in your drawer saying, well, if they wouldn't have came in my office and opened the drawer, they wouldn't have seen these types of things. All of that is not good in the workplace. You need this delicate balance here, where you're teasing someone versus just being offensive. Your behavior is offensive, but you haven't quite crossed that line. But then being practically unlawful when you literally telling these sexual jokes, you're not leaving it where you kind of interpret, like, I know what they really was saying and what they really mean. So you're not leaving this for interpretation here. You're just saying it. All of that is unlawful. And sexual harassment is one type of harassment. It is unlawful to harass anyone on all of the commission jurisdictional basis. You can have harassment on race, you can have it on sex, you can have it on disability, you can have it on national origin and ancestry. All of that is illegal. Oh, I didn't know if somebody was saying that. Okay.
We're good. Some questions in
Okay.
chat about credit, but we can keep going. Also, I just want to give a warning. We have about 6 minutes left on the
Right.
clock.
Oh, we're almost done. Gender stereotyping, again, that comes with sex discrimination. Uh, and if you say, because it's just illegal to discriminate based on one's sex, if indeed you are stereotyping, saying, that woman looks like a man, that man looks like a woman, all that stuff is illegal in the workplace. What does that person have on? That's a man. They're coming in fingernail polish. Look at that. Then that woman has some man. All of that stuff is illegal. There's no sexual stereotyping, and you definitely cannot harass people based on their sexual orientation in the workplace. That is just unacceptable. House Bill 352, that came into law in April 15, 2021. Before, under Gennaro, you could file individual against a supervisor, but now House Bill 52 says you can't file against supervisor and managers individually, but you can for retaliation and aiding and abetting. Something else that's important here, this is what gave us that 2-year statute of limitation in employment. It used to be just 6 months. Now it's 2 years. And now the Ohio Civil Rights Commission, we can issue what is called a right to sue letter. You must go through the Ohio Civil Rights Commission before you can go through court. Before you could bypass the Ohio Civil Rights Commission. We now issue a right to sue. It used to be just EEOC. They will issue it after 6 months of being in their system. We can issue the right to sue after 60 days of being in our system. Now, helpful hints. I want to give you some helpful hints really quick here. These are some of the common mistakes that supervisors that you make. Not following and applying policies consistently. Ignoring performance issues when they arise. You need to jump on that stuff. That policy stuff is so important. Follow your policy. Little or no communication. You're saying, oh, I've been writing down this stuff, but I didn't tell them. Not being candid on evaluation, telling the employee you are great, wonderful, the best that ever lived, and then turn around and say, I have to fire you for performance. Tell the employee, we are going in a different direction. You're going to open your cell phone up. Piling it on after the fact, giving them a whole list of things they're doing after they challenged you or was brought out. Flawed investigation or not taking any action at all. Well, I'm not going to investigate that. Making assumptions about individuals, thinking everybody appreciate jokes and behaviors, and engaging in behavior that's perceived as retaliatory. These are the types of things that we see. We see a lot of this mainly at the first line, what I call the first line level. So what might cause a person to say retaliation? And there's nothing that's going to protect you from retaliation, which is what the next slide is going to tell you. But it's retaliatory conduct or unfair treatment. If you have poor communication or it's a hostile environment, if they perceive any type of favoritism, they're going to say it's based on my whatever. If you're a new supervisor and you have a new managerial style, sometimes that causes a person to believe that they were discriminated against. If you know that a person has messed up and they've never been held accountable and you hold them accountable for the first time, oh yeah, that can be a problem. Everyone get good evaluations and then there's problems. Well, my evaluations were good. Now they're saying if someone has medical issues and then you come for them, and then if they perceive your discipline as unfair. What form of discrimination your agency seeing the most over the past year? I still believe that disability is leading the pack here in race discrimination. And just a word about policy and practices, just make sure they're clear. And if a charge is filed, all I'm saying is the most important thing to do, no matter what this slide is saying, you cooperate with the Ohio Civil Rights Commission. Know the deadlines, cooperate fully, because we have subpoena power. And there you go. Are there any more questions? What I want you to take away here is that we are a law enforcement agency. There are 5 commissioners here. They are the Ohio Civil Rights Commission. Anyone can file a charge, and we are a neutral agency. Just because someone filed a charge does not mean it's true, but we must investigate to see if our laws have been violated. Do I think what? Oh, okay.
Is there any recourse or any one group I should speak to? I believe Anthony following up on the question about being retaliated against for reporting a safety concern.
No, but just a safety concern would not be retaliation under our statute.
So if it's not jurisdictional for EEO, I guess they're asking where else should they look for help if they have an employment issue that's not jurisdictional?
I always say seek the advice of an attorney as to where you should go next, because it really depends. It may be a labor relation type problem. It may be something that even a union can cover, but I would just more or less say always seek the advice of an attorney.
All right. Well, thank you. We are right at time. Thank you, Darlene.
Well, thank you, everyone.
Thank you.
Thank you.
Yes, thank you, everyone. We hope you enjoyed the session. If you have any questions, please follow up with an email to us at odi@das.ohio.gov. A reminder, you can share feedback about this session and others at the link I put in chat. Just want to thank you again. Thank you for supporting Ohio's commitment to inclusion. And thank you, Darlene, one more time, and enjoy the rest of the sessions today.
All right. You all have been a great audience.
Thank you.
Bye.